So hello for the 6 of you that have joined so far. We've got 19 that we're expecting tonight, so I imagine people will just be joining as we go. Welcome to Ardent Residential's I joined my association board. Now what? I'm Colby Shear, Ardent's Director of Operations, and with me tonight is Michael Zenner, partner at Winter, Capriola Zenner, attorneys at law. They are one of Georgia's premier HOA attorneys. Thank you so much for being with me tonight, Michael. I appreciate it.
My pleasure.
This webinar is designed for new and seasoned board members to help you better understand your roles and responsibilities as board members. We're going to cover a range of topics, including what it means to be a board member, the expectations, terminology, legal considerations, and more. Feel free to put any questions in the chat, so we might just unmute everyone and let everybody join in the conversation, depending on how many more attendees join in the next few minutes. I do want to just remind everybody that this is just a general discussion and we cannot give specific advice on a specific community. So if you have a specific question for your community, please reach out to your manager or your attorney for advice. Without further ado, Michael, why don't you tell us a little bit about the organization and structure of community association?
Okay, they always leave the truly riveting topics to the lawyers, so I will dive right in. So yes, we both thought it would be good to begin with a brief overview of the structure and organization of community associations. You know, you're all board members or prospective board members, so we're gearing this, towards a level that tries to fit everybody. But with your questions, you can, guide us in different directions as we go along. But all planned communities, whether they're condominiums, HOAs, townhome developments, all planned communities are established by a recordation of a declaration of condominium and by a declaration of covenants and restrictions for communities that are not set up as a condominium. In very simple terms, in any of these communities, each owner, by owning a unit or a lot, is automatically a member of the association. The association's purpose is to maintain the common areas and facilities, enforce the restrictive covenants, and collect assessments from the members as required to fund its operations. Associations are set up in Georgia as nonprofit corporations under the Georgia Nonprofit Corporation Code. A common source of confusion is that they are not tax-exempt organizations. So they're not set up as a church or a school or a charity with all the very strict requirements that go with that. They're simply nonprofit corporations that aren't geared to make a profit, but are there to benefit their membership, which in this case would be the homeowners. Per the Nonprofit Corporation Code, which is the governing corporate statute of all associations, the board of directors is the governing body of the association. That's the body you've been elected to. And as the board, you have the power to make all decisions for the association except those that your documents expressly say have to be voted on or approved by the members. So you do occupy a position of considerable authority. It's helpful sometimes just to run through the statutes that come into play. And if I use shorthand to describe them, I'll try to describe the shorthand. But there aren't that many. There's only 3 of them. As I mentioned, the Georgia Nonprofit Corporation Code governs nonprofit corporations in the state of Georgia, and therefore it governs all community associations in the state of Georgia. If you're a condominium, you're governed by the Georgia Condominium Act. The Georgia Condominium Act is a mandatory statute that governs all condominiums in the state of Georgia. If you're a condominium, you are subject to the Georgia Condominium Act. The third statute is called the Georgia Property Owners Association Act, and because that's a lot to spit out, I'm going to refer to it as the POA Act whenever I talk about it tonight. But the POA Act, in contrast to the Condominium Act, is an elective statute. meaning not all townhome communities or single-family lot communities are subject to the Georgia Property Owners Association Act. An election has to be made either by the developer at the time the community is set up or later by the board of directors and the members who decide to amend the declaration in order to become subject to the POA Act. Now, in practical terms, developers rarely do it in the beginning because it ties their hands on things that serve their interests. It makes it harder for them to exempt themselves from paying assessments and to hang on to control forever and things like that. And so most developers don't do it initially, but what happens is after the developers have turned things over to the homeowners, the first elected board or one of the subsequently elected boards decides to become subject to the POA Act as an elective statute. And the reason they would do that is that it provides a number of benefits. It's a win-win for most associations that decide to become subject to it. In the area of assessment collection, it basically puts townhome or single-family lot communities that are subject to its provisions on the same grounds as condominium associations. And you get things like an automatic statutory lien. The association has an automatic lien for all amounts that are owed to it. There's no need to file paper liens or update them. And it just assures that the association is protected if there's ever a sale of the property. The POA Act, like the Condominium Act, also provides statutory late fees and interest. Courts have been very strict about late fees, particularly in recent years. And if you have the protection of a statute to back up your late fees and interest, that's a very beneficial thing. The statute, like the Condominium Act, gives the association the ability to foreclose, to get its attorney's fees whenever somebody is sued for assessments, and to foreclose its assessment lien in cases where it isn't practical to try to collect a judgment through garnishments, which would be the normal way that it's done. And the other thing that it does, both the Condominium Act and the POA Act, is it exempts the association from some problematic provisions of the statute out there. It's known in the industry as 44560. It's a general real estate statute that over the years has caused a lot of problems for associations. You know, one of the problems it's created, although it's largely now been addressed, is that initially it said restrictive covenants had a life of 20 years. And so before they changed the statute, a lot of communities discovered that their covenants had expired. Now, most documents allow for automatic renewal, and the statute itself provides for that to happen, you know, without further ado. But it's one problem but we still see some old documents that have the old language and dies after 20 years.
Wasn't it something about until the last ancestor of the Queen of England?
That's a perpetuities clause, which I think was noted in the recent Disney litigation too, but it's really kind of a meaningless provision that it doesn't really relate to the duration of the covenants. It's designed to avoid expiration through arcane legal principles that never really come into play. And then the other thing that's really been a bigger problem, and one of the big reasons why associations submit to the POA Act is because that problematic statute says that unless you're subject to the POA or the Condominium Act, if you want to adopt leasing restrictions or make changes to your existing use restrictions, even if you vote by 2/3 vote to do it, it can only be enforced against the people that vote in favor of it. But if you're subject to the Condo Act or the POA Act, it's clear that if the required majority of owners vote to adopt leasing restrictions or change or add the other use restrictions, it's enforceable against every single owner in the community, whether or not they voted in favor of it. And then the last category of the lawyer boring stuff that I'm going to go through is just the governing documents of the association. You hear that all the time, and it's a description that's attached to your documents as a whole that govern you. The most important one, and it's the first one I mentioned today, was the Declaration of Condominium or Declaration of Covenants. And in very simple terms, the way to keep that straight is it defines property rights and responsibilities. It does things like in a condominium, it defines what the units are versus the common elements. In a townhome or single family lot community, it defines what a lot is and what the common areas are. It sets forth the maintenance responsibilities. Typically, those provisions say that the lot owner or unit owner are responsible for maintaining their lot and unit or unit, and the association is responsible for maintaining the common areas or common elements. And they also contain restrictive covenants that affect what you can and can't do with the property. They're in broad terms, designed to address the appearance of the property. That's where architectural provisions come into play. Typically they'll say that, everybody bought into a scheme, an aesthetic scheme. And if you're going to make major changes to it, you've got to go to the association or its architectural committee and get approval for it. Other restrictive covenants relate more to the use of the property. You can't, things like pet restrictions and playing your stereo loud and things like that could cause a nuisance or a disturbance to other people. There are typically restrictive covenants that address those kinds of issues. And then a category that's become, very, very prevalent in recent years are leasing restrictions. And typically, some communities have no leasing restrictions at all. Any number of units or lots can be leased without any restriction. Some say that no units or lots can be leased, sometimes except in cases of undue hardship. But probably the most common way to address it is to have a leasing cap, where it would say no more than 10% or 15% or 20% of the units or lots can be leased. And then there's typically a procedure laid out in the documents where in order to lease, you have to apply for and obtain a leasing permit that allows you to do that. Leasing permits, leasing restrictions have become more prevalent in recent years. When I first started, it was largely something you only found in condominiums because those were the only types of properties that investors would typically buy to rent. But in recent years, I'm sure most of you have heard of these large rental companies that kind of entered the market after the Great Recession. And they're not just buying condo units, they're buying single family homes and townhomes, all over the country. And it's been a big thing in Atlanta. And what many associations that never had to worry about leasing before are finding is that all of a sudden they'll have one company come in and over a couple of years buy 5 or 10 or 15 or 20 lots within the community, which changes the character of the community, makes it more like a rental community with tenants that often don't care as much about the rules or the appearance of the property as somebody that owned would, and so it's just become a bigger thing that many associations have decided they need to address. The other thing that has led to an increased focus on leasing restrictions is the rise of Airbnbs and similar concepts where, and this is, it's with condo units, but also with houses where many people are now finding they can make a lot of money, especially if they're in a desirable area, to list their condo unit or their home on Airbnb and get hotel rates or even higher than that for people to come and stay for 2 or 3 or 4 days. And that's maybe great for the owner, but what's not so great for the community is then you have this constant stream of unvetted people, coming in and out, and that too changes the character of the community from a stable single family, owner-occupied community to one that seems more like a hotel or a rental complex. So that's
I noticed that a lot more lease restrictions are being written into the documents because municipalities are requiring developers to put them in, because the developer obviously would never want to limit its buyer pool to only owner or primarily owner occupied residents. But a lot of municipalities are saying, we don't need any more apartment communities. We don't need any more hotels. We don't need vacation rentals. We need single family homes, whether they be townhomes, condos, whatever. We need single family residences. So a lot of these are being required.
Yeah, you're absolutely right. And my experience has been the city of Atlanta certainly hasn't gotten on board with that and probably won't in the foreseeable future. But many
Yeah,
of the
they're not limiting them, but they're
smaller
starting to.
communities, the smaller communities, a little further out, have largely started doing that. And from my perspective, I think it's a good thing. I went off a little bit on what's in a declaration. But going back to the list of governing documents, the declaration is what I was just talking about. The other governing documents are the Articles of Incorporation, sometimes referred to as the Articles. That's the document that's filed with the Georgia Secretary of State that legally establishes the association as a nonprofit corporation. There are bylaws that are sometimes attached to the declaration, sometimes not, that govern the corporate affairs of the association. So the bylaws will address things like meetings of the members, the annual meeting, special meeting, how board elections are conducted, how officers are selected, records inspection, and things like that. Those kinds of corporate governance things are covered in the bylaws, whereas what you can do or can't do with the property is covered in the declaration. That's the way to keep them straight. And then rules and regulations are most bylaw declarations and bylaws give the board of directors the authority to adopt rules and regulations without going to the members for approval. They're published and they can be updated easily because they can be changed, just by a board vote. But they are there to sort of flesh out the restrictions that are contained in the declaration. They can even add new restrictions, but they can't have anything in them that's inconsistent with the declaration. And then design standards you sometimes hear about are really just a subclass of rules and regulations. They're adopted by the board of directors or sometimes by the Architectural Control Committee. They can be changed by the board or the ACC. They're not reported, and they kind of lay out the process for getting architectural approval and guidelines as to what is generally acceptable or not acceptable in the community. And that's pretty much it. So I think you get into those things, and then you get to the meat of this, which is the board of directors, which our expert Colby is going to deal with now.
Which is so invigorating, but it's what you're all here for. So I am going to go ahead and share my screen because I thought it best just to go ahead and show you kind of an example of a typical set of bylaws, which is where you're going to find usually your structure of your board of directors, how members are elected or appointed. So let's start at the beginning with this particular set of documents. Now, they're all written differently. You'll find a lot of them are written very similarly. There were kind of 2 years ago, 2 big firms that wrote most of the documents, and then you'd have a couple of builders that would do their own documents, or a couple of smaller attorneys that didn't necessarily specialize in HOAs. But most of the documents kind of spawned from these 2 law firm giants who have now sprinkled about, and now there are many, many firms with many attorneys to choose from, all of which are great in their field. And so you have, I'm not saying these are a typical set of bylaws, just that they're fairly typical for what a bylaw states.
Colby, sort of an interesting note for people that don't know the history. I mean, when you look back on it, it's sort of interesting, but 35 or 40 years ago, there was literally one firm in Atlanta that did about 90% of the community association work, and it was called Hyatt Rhodes. And it split off into 2 pieces, and then each of those pieces split off into pieces. And from that original, ancestor, Hyatt and Rhodes, you now have the law firms that collectively probably represent 80 or 90% of the communities in the Atlanta area.
Right. Yeah, so generally you're going to start with your board of directors, and that's just the general membership. So once Class B, which is usually the builder or the declarant developer, turns over control to the homeowner, you're going to first start with your first homeowner election. Most documents, well, let's say preferred documents, are going to go ahead and set that first board up to have staggered terms. So, for example, this particular document states that the two candidates with the most votes shall be elected for a term of 2 years, and the candidate with the least amount of votes shall be elected for a term of 1 year. Now, I've gone to meetings that are exactly like that in the documents, and everybody has the exact same number of votes, in which case we just draw straws. Or there's one person who says, I'll gladly take the 1 year. So that usually works itself out. I've only highlighted the sections that are really relevant to once the declarant has turned over to the homeowners. So the next section in this discusses appointment and election. Funny because it doesn't really discuss appointment, it just discusses election. So after the Class B membership, the members of the board of directors shall be elected at each annual meeting of the members of the association and shall serve for a term of 1 year. Now, clearly that conflicts with what was just said, that they will actually be elected for a term of 2 years. And we can tell that the first provision was put in place so that there were staggered terms. You weren't turning over a whole new board every year as 1 year terms would do. So we're going to safely go with the first section that says 2 year terms after that first election.
And just as an aside, I mean, if you ever see in your documents something like that that's obviously just an error by the drafter, there is a relatively easy way to fix it. You can go to the law firm or whoever handled the drafting of those documents and recorded them, and get what's called a scrivener's affidavit or a corrective amendment, where the person who prepared them basically says, yes, I made a mistake, this is the way it should have read, and then the document is deemed to be amended to read the way it should have been. So a scrivener's affidavit or corrective amendment can be done very easily without any requirement of an owner vote.
Thank you. It goes on to discuss vacancies, and that's how a lot of new board members end up on the board. You've got your board happily running along, whether it's 3 members, 5 members, 7. I've seen as many as 9. We usually say halt it there. It's hard enough to get 5 people to agree on everything. Once you get up to 9 and go past that, it's almost impossible to get through a productive meeting. So, but typically if a member resigns, which usually will happen if somebody's moving or if you're not getting quorum at your annual meetings, so you can never elect the next successor. People end up just stuck on the board for years because you're on the board for your term or until your successor is elected. If there's never a valid meeting after you are elected, your successor is never elected, and congratulations, you're a lifelong board member. So often they will quit, and the remaining board members are then tasked with appointing someone to fill, depending on the documents, either the unexpired term or to fill the vacated position until the next election. And it's going to go into the duties and powers of the board. This one is just pretty broad because the documents talk about that all throughout. And this one just, really ratifies that the duties of the board are to uphold the governing documents, which are all of those statutes that Michael mentioned, plus the association specific governing documents, and then also to suspend the rights of any member and to enter into management agreements. Very important one. Then it discusses meetings. Now, this particular set of documents only discusses regular meetings. The important part of that for the board to know is how many meetings do you have to have a year? This particular board only needs to meet no less frequently than once every 6 months. Now, they can choose to meet more than that, but that's the minimum that they can meet. It also addresses special meetings, and this set of documents actually allows that the board can be compensated if 2/3 of the community agree. The majority of documents I've seen have said they cannot be compensated at all.
And by not compensated, that also includes, I get asked all the time, well, if we can't compensate them, can we waive their assessment as a way of recognizing the time they spend as a director? The answer is no, that's compensation, and that would be subject to the same provision.
Yeah, I've run into that one a lot too, Michael. And I had a board years ago. In fact, it's funny, it's this same board keeps coming to mind that disregarded professional advice entirely that they got from both management and from legal counsel saying, no, your assessments are not exempted. And they said, okay, well, we're not going to compensate ourselves for being on the board until we've actually served the whole year. So we'll go ahead and pay our assessment and then get it back at the end of the year. We stay on the board the whole year. You're still compensating yourself. So another homeowner did actually get an attorney involved, and they stopped that just pretty quickly. But next, it's going to go into the officers. Remember that the membership elects the board of directors, the directors themselves, and then the directors actually elect or appoint the officers. So this next section is going to talk about what officers this corporation is required to have and what duties are for each of those officers. And this one specifies, so if you noticed, this particular association is only required to have 3 board members. So it's required to have 4 officers. So you think, all right, the math doesn't really add up there until you realize that any 2 or more offices can be held by the same person, except the offices of president and secretary. And some documents will vary on that. Sometimes it's president and treasurer. Sometimes no 2 offices can be occupied by the same person. Sometimes officers don't even have to be board members. That's a whole nother rabbit hole. So then they're going to go down through what each person's role is. And what I really want to highlight in this is that while each board member has a specific role and a duty and an expectation, no individual board member actually has any power than another board member. So the secretary out on a walk can't approve an ACC request for somebody's payment plan. The president can't do those things either. The president calls meetings, presides over meetings, signs contracts that the board has voted on. But the board speaks as a single voice. It's an entity that represents a corporation, a nonprofit corporation.
That most often comes up in my experience. Every once in a while, you'll get a president who thinks, he or she is the chief executive officer. So they should be able to basically make all decisions on their own without input from the board. But that could be quickly controlled, because what you see under the 5.2 appointment provision there is, if a president gets out of hand like that, he really doesn't have any power, because if the rest of the board is unhappy with the way he's conducting himself, or if he's doing things that they haven't approved, or otherwise making trouble, all they have to do is vote to remove him, and then he's no longer president.
Right. And the duties that are required of the different offices, I really want to highlight the secretary and the treasurer. I think they have the most serious responsibilities, because the secretary is responsible for keeping the minutes of the meetings. That means attending every meeting, keeping the books and records of the association. And the treasurer is responsible for overseeing the books and the financial records of the association. Now, often those things are contracted out to a management company, but ultimately, as the secretary or treasurer, you still need to make sure these things are being done. One thing a secretary should never be asking their manager to do is keep minutes. I know there are some managers out there that do it. We actually don't allow our managers to do that, because they are the legal record of the association, and therefore should be prepared by the secretary and attested to by the secretary. We will gladly keep them with your books and records. We'll gladly post them online once they've been approved at the next meeting. We'll certainly be custodian of all of that, but we really encourage that the secretary keeps the minutes. And speaking of minutes, now I'm on my high horse here. Speaking of minutes, minutes are a record of actions taken, where, when, and who. So where a meeting is held, when a meeting is held, who attended the meeting, and what actions were taken at that meeting, and what time did the meeting end. It is not a transcript of all the conversations held at the meeting. So you want to know, was a motion made to take an action? If the motion was made, was it seconded? And then did the motion carry? By how much? If you've got 3 board members, if it carried, it's probably going to be 2-1 or 3-0. So all in favor, or was it defeated? And then I have seen on some more passionate issues where a board member has demanded the secretary notate in the minutes the way they voted, because they didn't want the association to be angry with them for voting for or against whatever this hot button issue is. And the fact is, the board speaks as a single unit and as a whole. So what do you think, Michael? Should board members be able to have that noted in the documents if they voted against a motion that carried or voted for a motion that was defeated?
I think that both for membership meetings and for board of director meetings, I think you're right. The practice is, unless somebody says something like that, either it will be very generally say the board voted by a vote of 3-2, to adopt something. That's the normal way that it would be notated. But no, I do think that if somebody specifically asks that the minutes reflect how they voted, I think it's their right to insist that that be put in there.
All right.
I don't like it. I wouldn't encourage it, but I think if a client came to me and said they want this they want it noted in the minutes that they voted against this, I would say put it in there.
Yeah. Okay. So one thing that those particular documents don't address that I did want to talk about briefly is executive session of board meetings. That is often misunderstood. So many documents require that the board give notice to the membership for when meetings are being held. That does not mean that homeowners can participate in those meetings, just that they may attend them. Now, unless you have like an open session at the beginning of your meeting or you call the meeting to order, it's really a good idea to keep Robert's Rules of Order and only have people that are participating in the meeting, which are the board members and anyone who has been placed on the agenda and invited to participate. So most business should be handled in an open board meeting, with the exceptions of litigation, personnel issues, or personal issues with specific homeowners. So if you've got a hearing violation that wants to be heard, don't do that in open session. Go ahead and adjourn the meeting. Have them come towards the end of the meeting, adjourn the meeting, go into executive session, have your hearing, you hear them out, you let them go, then the board discusses, votes, noted in the minutes, separate minutes from the open meeting, separate physical documents. Sorry, just heard a door open. Oh, yes, I did. Oh, okay, sorry. Somebody just walked in my office and scared the crap out of me.
It caused quite a reaction. I'd like to see who it was.
I did not expect to see somebody come past my door. Okay, so yeah, open board meeting minutes need to be physically kept separate from your executive session meeting minutes, because regular board meeting minutes are open to records requests. Executive meeting minutes are not, unless they are subpoenaed. So they need to be maintained separately. Executive meeting minutes should never be posted online, never be posted to the general public. If you've got a board only section, you can post them there, but they should never be posted for all of the homeowners to see, because that's going to be some really sensitive information usually. You want to weigh in on that?
No, I think you've described it exactly the way I would. It's amazing. I mean, a lot of associations, in my experience, just don't keep executive session meeting minutes. They adjourn to executive session. The regular minutes say that, and then they figure we all know what we talked about in executive session, so there's no reason to have a written record of it. But that's really not a good practice. You don't want it on the open meeting minutes for the reasons that Colby just described. But it is a really good idea to have separate executive session minutes that reflect the decisions that were made in executive session. So 2 or 3 years from now, when there's different people on the board and an issue comes up that relates to a decision that was made during that time frame, you have a written record that you can consult. Otherwise, you're just left to guess at what happened. So they should be maintained, and they should be kept in a place where they're not disclosed to the members.
Right. And you don't want to abuse executive session either. It should really be kept for sensitive items only. I have had boards that they knew something was going to be controversial, so they really wanted to hash it out just between them before any homeowners could really get wind of it. That's not an executive session. That's a board meeting discussion, unless you're talking about pending or possible litigation, or a homeowner specific issue, a collections matter, whether or not you're going to fire someone, those kinds of things, executive. Otherwise, the homeowners have the right to know whatever it is you're considering, even if you think you're going to, get stopped walking your dog, you have to hear about it. All right. So, I think we hit on how decisions are made, not by a single member, and preferably not by one very passionate board member slamming their hands on the table and yelling at people and holding them hostage for 4 hours until they vote the way they want them to vote, which I've had happen. Um, meetings should really, if you're taking more than an hour, unless you have a lot of very complex situations going on in your community, your board meetings should be where you review your management report, review any committee reports for the meeting. You come into the meeting, you sit down, you make motions, you take votes, you have any more conversation on issues that you need to have. You adjourn into executive session if needed. And if not, you adjourn and everybody goes home. I think that boards are getting a better handle on that after the pandemic pushed everybody to Zoom, and it's not nearly as much fun to sit on your computer and talk to your neighbors as it used to be to sit, with a drink in your hand and talk about the neighbors and the neighborhood. And, it used to be a social 2 or 3 hours. Poor manager still hasn't gone home and had dinner yet. So I think just remembering it's a business meeting, get it done, and everybody will be happier. I am going to kind of unmute everyone so that if anybody would like to actually ask questions, you can.
Yeah, I think that's a good idea. I mean, we've got about 15 minutes left. There's certainly other things that we could cover, and we can
Absolutely.
if nobody has anything else to chime in about. But I think it would be great at this point if all of you that are, have been listening to this could either ask questions that we'll try to address, or maybe suggest other topics that relate to serving on the board that we didn't address, and we'll do our best.
Right. Well, until any questions come up. So the time commitment of being on the board really varies greatly depending on the complexities of the community, the complexity of the issues that you're dealing with, the effectiveness of the relationship between the board and the management company, as well as your other contractors and vendors like your attorneys. When you're really working as a team, your board member time commitment should be fairly minimal. Back in the olden days, when I started in this industry, um, emailing in business was just not as common as it is now. Very few people had computers in their homes. So, in preparation for a board meeting, a week before, we would compile the board packet and the financials, and we would physically mail a hard copy off to each board member. And then a week later, we'd gather at the meeting spot and have our meeting. And then the manager would go off with their action item list and their tasks and their projects. And you really didn't talk to the board very often between meetings. You might hear from them once or twice between meetings, or if an emergency came up, but it was not this constant contact that has happened with email. Hey, Amanda, I see your hand is up.
Hi, I have a question. I am the treasurer on the board, and I am, I guess, one of those who falls into the category of a lifetime member. We never meet quorum.
Welcome.
So I've been on the board for going up for 4 years now. And I was wondering if you guys would consider facilitating a meeting where board members can get in a Zoom meeting and talk about best practices, like kind of bounce ideas off of each other. Like we encounter a lot of different things, and I was just wondering if, like if we could talk about the way things happen in their community. Maybe I could learn from a treasurer in another board or our president or something like that. Does that make sense?
Yeah, I love the idea of a board member roundtable. Like maybe
Yes.
we invite all of our treasurers to come in one day or to a Zoom, or all of our presidents, or just all of our boards, whoever
Right.
would like to join. I think that's a great idea, Amanda. I'm writing it down.
Okay, I'd be very interested in participating in that.
Awesome idea. Thank you.
Thank you both very much. This was good.
Thank you.
It's our pleasure. Okay. So what else, Michael, do board members need to understand about board duties and their fiduciary duty to
Yeah, I
the
mean, I can
community?
quickly run over, what the duties are. I mean, you hear the term fiduciary duty, nowadays, I think you usually hear it on these commercials for brokerage firms that brag about being a fiduciary rather than somebody that's out to make a commission on your trades. But it does, relate. Board members also have a fiduciary duty, and all that means is legally, and it's set up under the Georgia Nonprofit Corporation Code, is that as a director, you have a duty to put the interests of the members and the community as a whole above everything else, including your own self-interest. So if you ever have any kind of personal interest in a board decision where what you're thinking would benefit you conflicts with what might benefit other members of the community or the community as a whole, you have a duty to disclose that and abstain from the vote. So your duty is to not look out for yourself. It's to always look out for the interests of the membership as a whole and the community as a whole. And that kind of makes common sense, but that's kind of the underlying duty that all directors have. It's in terms of what the specific duties and responsibilities of the directors are, they're what's laid out in the governing documents. Because you're the governing body of the association, your duty is to actually carry out the duty of the association under the covenants. And so you look to the covenants to see what the duties of the association are, and that's where you see what your duties are, because your duty as a governing body is to carry out and make sure that the association's duties and responsibilities are fulfilled. One major thing that every board has to do is adopt a budget. That's something that we can just briefly address. Go ahead, Colby.
Adopt a budget that actually covers the expenses of the association, please.
Yeah, I mean, basically what's supposed to happen when you do a budget is you're supposed to, as board members and as the management company also, look at what you've spent during the preceding year and sort of look to see what you expect to spend in the coming year, and then set up an expense budget, which estimates the best way you can how much money you're going to need in each of the budget categories during the coming year. How much do you need for legal fees? How much do you need for management fees? How much do you need for landscaping? How much do you need for cleaning? Every major operating budget category. What did you spend last year? What do you expect to spend in the coming year? What should you estimate as your expense budget for that coming year? And then you figure out what those expenses are. And then you have to see whether your current assessment is enough to cover those expenses. If it is, great. But if it isn't, you're either going to have to go back and cut some of the expenses or raise the assessment. And included in all of that should be not just operating expenses, but you have to remember that every year you should also include in that budget a set aside or a reserve fund that's intended to deal with future capital repairs that have to be done, unexpected things that might come up, and so forth. So you develop an expense budget based on your past experience and what you think your future experience is going to be. You add to that a reserve contribution that's based on what you anticipate you're going to need in the future to cover anticipated capital improvements and repairs, usually according to some kind of a reserve study. And then you make sure that you set your assessments at a level that's adequate to cover all of those things, your operating expenses and your reserve contribution. And then you put those two pieces together and you have an expense budget, a revenue budget. Between the two of them, they're the budget. They have to balance, unlike our government. And then that's what you go forward with. Now, in some communities, the board adopts it and that's it. In some communities, the board adopts it, but they have to get approval if it results in an assessment above 5% or 10% or some specified amount. But what most documents now say is that the board, because they have much more information than the other members, is better qualified to make the decisions on the budget than a general member would be. So what most documents say now, in my experience, is that the board adopts the budget, it's presented to the members, usually at the annual meeting, and then it's deemed to be approved unless somebody stands up at the meeting and says, I move to disapprove the budget, and that motion to disapprove is carried by usually a pretty large vote, like a majority of the total association vote, which is usually more than you even have present at the meeting. So I think in 30 years or 30 plus years of doing this, I can only remember 2 or 3 times that a budget adopted by the board was successfully overturned. You need to have a lot of people that don't like it, and you have to have a lot of people at the meeting, and that rarely, in my experience, happens. Based on the budget, you set the assessment. Collecting those assessments is sort of the day-to-day drudgery that every association has to live with. Most people pay when they're billed on time, but some people don't. And you have to have a collection policy in place to deal with that. Usually it's sending out invoices or coupons. If they don't pay, they'll get a late notice from the management company, maybe another letter from the management company saying you need to pay or we're going to have to take further action. And then if they don't pay, it goes to the law firm and you have to get more official about it and send demand letters and file liens and file lawsuits. You always hope to resolve assessment debts without having to do those things. So I think the goal of most collection programs is to gradually increase the pressure so that people pay before you have to file a lawsuit and incur big legal fees and create that kind of situation. And then I think the last thing I just will touch on quickly is, you've got these restrictive covenants in the declaration, you've got the rules and regulations and design standards. The question then is, what do you do if somebody doesn't comply? And there are basic remedies that every association has under their documents, or at least they should have if their documents are well written. Probably the most common enforcement mechanism are fines that can be assessed. So, if somebody puts a purple statue in their front yard without getting ACC approval, you send them a letter, say you didn't have approval to put the purple statue in the front yard, remove it within 14 days, or we'll assess a daily fine of $25 a day until you remove it. Or, if they painted their house without approval, repaint it the original color, or get approval for the color that you painted it within 30 days, or some kind of daily fine will be assessed. Or if somebody has a loud party and there's 50 cars blocking the streets and they disturbed all the neighbors and the police were called, the board could decide, a reasonable fine for that is $500. There's no opportunity to correct it because it's not correctable. It's already been done. So in that case, you would just impose a fine for something that's already happened. And many documents now have sort of a due process, provision in their documents where the board can't just assess a fine. It has to give the homeowner an opportunity to contest it. And usually the way that works is if you send a letter to the owner saying we're imposing a fine or we will impose a fine, you can the owner can request a hearing before the board of directors to contest either the fact that they were in violation of the declaration or the fine that was assessed. And then after conducting that hearing, the board can make a final decision on the fines. So fines are probably the most commonly utilized enforcement mechanism. A second is self-help, which means that if somebody doesn't maintain their property, that's probably the most common example of when self-help would be used. If they don't mow the grass or there's garbage in the yard or something like that, the board can, or the association can write a letter saying clean it up, or we're going to come in and clean it up and bill you for the expense. Most documents give the association the ability to do that. As a practical matter, self-help works best with vacant lots where you're not going to have a homeowner with a gun coming out to do something that they don't like. But it's generally limited to situations where you can go in quickly without spending a lot of money to abate a violation and then charge the expense of that to the owner. But day in and day out, it's not utilized all that much. Colby,
Michael, I have a fantastic abatement story. So abatement was used very, very frequently from, somewhere in 2008 during the whole global financial crisis when all those homes were in foreclosure. Communities really used abatement a lot to try to keep the houses, all the foreclosed homes looking.
And it was a situation again where they were vacant homes.
Yes, but years prior to that, early in my career, we had this home. It was just frustrating the heck out of myself and the board members. They had started painting the house, and they had gotten the siding. There was very little siding. It was a mostly brick house. And then they only painted the shutters on the ground level. They hadn't painted the shutters on the second floor. So we tried fining them. We tried calling them. The board members tried going over there and knocking and talking to them. And we finally said, we're going to abate it. We're just going to get a painter that we can find that'll go over there and do that. And I know one guy who might. Okay, so I called him and I explained the situation, and he said, oh, yeah. He's like, this will be fun. So I went out because I wanted to see this. He goes out, he parks a couple of doors down, runs over with his ladder on his shoulder, throws the ladder against the house, runs up the ladder, smacks some paint on one shutter, smacks it on the other, jumps back down the ladder, pulls that thing and runs back down the street. Like, you only got one done. He's like, I'm coming back tomorrow. They'll never see it come. He got them done. Sometimes you have to get creative. I don't recommend that. That's not a recommendation, but
yeah, I mean, that just goes to show if there's a significant risk of a confrontation with a homeowner, it's probably best not to do it, especially in today's world. So if it's a vacant lot or a foreclosed property, or the owner's gone, during certain hours, and you can get in quickly and cheaply and do it, then yes. But for the most part, the stories are better than the reality. The other things that you can do for enforcement are suspending. If somebody's delinquent or in violation of the rules, you can suspend their voting rights, possibly take away their right to run, for a position on the board of directors. If you have amenities, suspension of use rights is another remedy that can be imposed until you pay your assessments or get in compliance with the covenants or the rules. You can't use the amenities. Sometimes they'll even say you can't park your car in the parking ramp, or you can't have automatic gate access. I mean, there's things like that can be done to try to enforce compliance.
Yeah. Can't drive on the private roads.
Drive on the public. Yeah, your house is 2 miles back, and they're going to say we're suspending your right to drive vehicles on the road. So if you want to get in, you've got to walk the 2 miles after you're let in the gate. So, different associations, have different policies on that. They have to be reasonable. And, if something doesn't pass the reasonableness test, it's probably, if you think it might not, it's probably good to check with your legal counsel just to see how they think a court would react to it if it were put before a judge. And then that leads me to the last legal remedy, which is of course, filing a lawsuit. That's always usually a last resort. If all the other remedies, fail or don't get compliance, you can file a lawsuit. That's more contentious than any of the other ones. It costs everybody money. And so if there's a way to avoid it, it's good to avoid it. But if you really can't get compliance any other way, you can get a lawsuit to collect the assessments or get an order for people to repaint their shutters or mow their grass or whatever it is, or give the association a judicial order right to go in and do it. And then you're in a much better position than you would otherwise be. But that's it, the enforcement arena.
Yeah, some documents actually also provide a provision that before the association files suit to gain compliance, that you go to arbitration. So I have also found that sometimes it's very effective. Sometimes the other parties just won't participate, and so you end up in court anyway. But if you can do arbitration instead of a lawsuit, it's always going to be preferable. And the judge is going to really appreciate that you made the effort to try to resolve it before getting on a court calendar. I think that's our time for today. Any last minute questions?
Any final questions?
Okay, everybody. All right. Well, I thank you so much for joining us. Michael, thank you so much. You made this so much better than I could have done on my own.
My pleasure. I learned a lot tonight, like I do every time I listen to Colby. She's been doing it for a long time. So thank you.
I always learn a lot from you as well. Thanks so much. Hey, if any of you have suggestions on future webinar topics you'd love to see, feel free to drop us an email, comment on one of our many social media posts, or just, give us a call.